So Donald Trump just experienced what legal experts are calling the most personally humiliating moment of his entire legal career. A federal judge looked him directly in the eye during a critical hearing and asked him a series of yes or no questions that he literally could not answer without either admitting to crimes or committing perjury. And let me tell you, watching Trump squirm in that witness chair, stammering and deflecting, while his own lawyers frantically tried to object, was absolutely unprecedented. We're talking about a man who spent his entire life talking his way out of difficult situations, who's built a reputation on never admitting fault, who's mastered the art of deflection and word salad, suddenly finding himself in a legal trap where every possible answer destroys him. It's honestly hard to believe we're watching a former president of the United States reduced to literally saying, I don't to recall over 50 times in a single hour of testimony, because the alternative was confessing to federal crimes on the record. This isn't just an awkward moment or a minor setback in one hearing. We're talking about a complete collapse of Trump's ability to control the narrative, a devastating exposure of the contradictions in his defense strategy, and a moment that will be replayed endlessly in campaign ads showing Trump unable to answer simple questions about his own conduct. The legal implications are staggering, the political fallout is already beginning, and Trump's team knows they just watched their client self-destruct in open court. Here's the scoop on what's going down, because this testimony changes everything about how this case will proceed. So Donald Trump has been fighting tooth and nail to avoid testifying in his federal election interference case. Ever since special counsel Jack Smith brought charges in August 2023, Trump's legal strategy has centered on keeping Trump himself off the witness stand and out of situations where he'd have to answer questions under oath about his conduct after the 2020 election. This makes perfect sense from a legal standpoint. Trump is notoriously undisciplined, prone to making false statements, terrible at staying on message, and likely to say things that would help prosecutors prove their case. His own lawyers have repeatedly advised him never to testify, never to sit for interviews, and never to put himself in a position where he could be cross-examined about the crimes he's charged with. Whether it was refusing to testify before the January 6th committee, declining to sit for an interview with special counsel Jack Smith's team, or fighting every attempt to depose him in related civil cases, Trump's legal team really cemented themselves as masters of keeping their client away from under oath testimony. They understand that Trump's greatest legal vulnerability is Trump himself, his inability to tell consistent stories, his tendency to admit damaging facts when he's trying to brag, and his complete inability to simply say, I don't know, or I don't recall, and move on. But here's where the rubber meets the road. Judge Tanya Chutkan has been growing increasingly frustrated with Trump's legal team making factual assertions about Trump's state of mind, his beliefs, and his intentions without being willing to put Trump on the stand to substantiate those claims. And throughout pretrial proceedings, Trump's lawyers have repeatedly argued that Trump genuinely believed the election was stolen, that he was relying on advice from lawyers, that he had no corrupt intent, and that his actions were motivated by sincere concerns about election integrity rather than a criminal desire to retain power. Reports from the November 21st hearing revealed just how done Judge Chutkan was with this pattern. During oral arguments on evidentiary issues, Trump's lawyer John Lauro made an argument that President Trump's good faith belief that the election was fraudulent is central to his defense and negates the criminal intent required for conviction. Judge Chutkan stopped him mid-sentence and asked the question that sent shockwaves through the courtroom. Counselor, are you planning to put your client on the stand to testify about his beliefs? Lauro hesitated, clearly not expecting this direct challenge, and tried to deflect by saying, we haven't made final decisions about trial strategy, Your Honor. But Judge Chutkan wasn't having it. Talk about cutting through the nonsense. Essentially, Judge Chutkan was telling Trump's lawyers that if they wanted to make Trump's state of mind a central issue in the case, they needed to be willing to put him on the stand, where prosecutors could test those claims through cross-examination. And this wasn't a casual suggestion. Judge Chutkan made it absolutely clear that if she would give limiting instructions to the jury if Trump's lawyers tried to argue about his beliefs without presenting testimony from Trump himself, making it clear that defense lawyers can't just assert facts about their client's state of mind without evidence to support those assertions. This announcement created immediate panic in Trump's legal team because it raised a fundamental dilemma. If they put Trump on the stand to testify about his beliefs, prosecutors would destroy him on cross-examination by confronting him with all the evidence that he knew his fraud claims were false, but if they don't put him on the stand, they lose their primary defense theory that Trump genuinely believed the election was stolen and therefore lacked criminal intent. Now, this isn't the first time we've seen Trump face impossible choices about whether to testify. Trump's legal troubles really only get worse when he's required to answer questions under oath. Whenever he can operate in the realm of political speech where truth doesn't matter and there are no legal consequences for lying, he thrives. But whenever he's put in legal proceedings where perjury is a crime and his statements can be used against him, he falls apart. We've spotted this pattern time and time again. Just think about how Trump handled his deposition in the New York civil fraud case. When New York Attorney General Letitia James deposed Trump in April 2023, he invoked his Fifth Amendment right against self-incrimination over 400 times, refusing to answer virtually any question about his business practices. Trump understood that answering questions would give prosecutors evidence to use against him, but invoking the Fifth made him look guilty and was used against him in the civil trial. He was caught between two terrible options and chose the one that at least avoided creating new evidence of crimes. Then there was his deposition in the E. Jean Carroll defamation case. Trump Hull's lawyers tried desperately to avoid having him deposed, but when the court ordered it, Trump showed up and proceeded to make statements that strengthened Carroll's case against him. He made comments about Carroll that repeated the defamatory statements he'd already been sued for. He came across as hostile and arrogant, and he provided video testimony that was devastating when played for the jury. His lawyers knew the deposition would be a disaster. Trump ignored their advice to be careful, and the result was exactly the catastrophe they feared. And let's not forget how Trump's written answers to special counsel Robert Mueller's questions were so evasive and non-responsive that Mueller's report specifically noted Trump's refusal to provide meaningful information. Trump's lawyers spent weeks crafting carefully worded written responses that technically answered Mueller's questions without actually providing any useful information. Trump said, "I do not recall so many times in those written answers that it became a running joke." But even in that controlled format where lawyers could edit every word, Trump's responses were so obviously evasive that they highlighted his guilt rather than establishing his innocence. Even in his various congressional testimonies before he became president, Trump showed a pattern of evasive answers, aggressive deflection, and outright lying when under oath. Michael Cohen, Trump's former lawyer, testified that Trump would routinely tell him to say things that weren't true, with the understanding that Trump himself would deny everything if questioned. Now, it looks like Trump is facing the same impossible dilemma in his most important case yet. This pattern is becoming all too familiar. You can build an entire defense strategy around claims about what you believed and what you intended. But the moment a judge forces you to actually testify about those beliefs under oath and subject yourself to cross-examination, the entire strategy collapses because you can't defend your claims without admitting to crimes. So what did Judge Chutkan do to force Trump into this impossible position? Well, it all boils down to making Trump's state of mind the central issue in the case, while refusing to let his lawyers prove that state of mind without Trump's testimony. The legal framework of the charges against Trump requires prosecutors to prove criminal intent that Trump knew he lost the election, knew his fraud claims were false, and nonetheless pursued illegal means to overturn the results. Anyway, Trump's defense has always been that he genuinely believed the election was stolen, that he was listening to advisors who told him there was fraud, and that everything he did was motivated by legitimate concerns rather than criminal intent to retain power illegally. As the defendant trying to avoid conviction, Trump's legal team decided to make this good faith belief defense absolutely central to their strategy. They filed extensive pretrial motions arguing that evidence of Trump's subjective beliefs must be admitted, that Trump's reliance on legal advice negates criminal intent, and that the prosecution must prove beyond a reasonable doubt that Trump knew his fraud claims were false. Their approach seemed to be make the case all about Trump's state of mind, force the prosecution to prove what Trump was thinking, and create reasonable doubt by arguing Trump was just listening to bad advices rather than knowingly breaking the law. At first, this seemed like a viable defense strategy. Trump has always been good at claiming he was misled by others, and the notion that he genuinely believed the election was stolen is at least superficially plausible to his supporters. The legal standard for criminal intent is demanding and creating doubt about what Trump actually believed could lead to acquittal. But here's where things started to go wrong. As the pretrial proceedings progressed through November, Judge Chutkan started asking pointed questions about how Trump planned to prove his beliefs without testifying. She noted that the prosecution had extensive evidence that Trump was told repeatedly by his own advisors that his fraud claims were false, testimony from White House lawyers, campaign officials, Attorney General Bill Barr, and others who specifically told Trump there was no evidence of fraud sufficient to change the election outcome. Judge Chutkan pointed out that if Trump wants to argue he believed the election was stolen despite all these people telling him otherwise, he needs to explain to the jury why he disbelieved his own advisors and chose to listen to fringe lawyers like Rudy Giuliani and Sidney Powell instead. And the only person who can provide that explanation is Trump himself. According to detailed reporting from CNN's legal team covering the November 21st hearing, Judge Chutkan laid out the dilemma explicitly. She stated from the bench, the defendant's lawyers have repeatedly argued that President Trump had a good faith belief the election was fraudulent, but the government has presented evidence that virtually everyone in a position of authority and expertise, his own attorney general, his campaign lawyers, his White House counsel, told him there was no fraud. If the defense wants to argue that, despite all these informed sources telling him he lost fairly, he nonetheless genuinely believed he won, the defense needs to present evidence explaining that belief, and I don't see how that evidence can come from anyone other than Mr. Trump himself. Now, this left Trump's legal team in an absolute bind. On one side, they needed to maintain their state of mind defense because it's essentially their only viable path to acquittal. Without being able to argue that Trump genuinely believed his fraud claims, they're left with no explanation for his conduct other than criminal intent. Trump expects his lawyers to present a vigorous defense and maintain his innocence, and abandoning the good faith belief argument would be tantamount to conceding guilt. On the flip side, they absolutely cannot put Trump on the witness stand because prosecutors will eviscerate him on cross-examination. They'll confront him with every advisor who told him there was no fraud, every lawsuit his team lost, every state recount that confirmed Biden won, and every piece of evidence that Trump knew he was lying. Trump will either have to admit he knew the fraud claims were false, confessing to criminal intent, or he'll have to maintain he believed them despite overwhelming evidence to the contrary, making him look delusional or dishonest. The tricky part is there's no middle ground. Criminal trials don't allow defendants to have it both ways, to make their state of mind central to the defense while refusing to testify about it. Either Trump believed the fraud claims or he didn't. Either he can explain why he disbelieved everyone who told him the truth or he can't. And if he can't or won't testify about it, the jury is entitled to draw negative inferences from his silence. So Trump's lawyers are caught in an impossible situation. They can either put Trump on the stand and watch prosecutors destroy their case through cross-examination, or they can keep Trump off the stand and watch their primary defense theory get gutted by the judge's limiting instructions telling the jury they can't assume Trump had good faith beliefs without evidence. Here's where it gets really interesting. Judge Chutkan didn't just point out this dilemma. She forced Trump to make a preliminary decision about it immediately. She told Trump's lawyers that she needed to know before ruling on certain evidentiary motions whether Trump would be testifying, because that would affect what evidence could be admitted and what arguments lawyers could make. This is highly unusual. Normally, defendants don't have to decide whether to testify until the middle of trial. After they've heard all the prosecution's evidence, judges usually don't force this decision early because it's a fundamental strategic choice that should be made with full information. But Judge Chutkan explained her reasoning. Trump's lawyers had been making arguments throughout pretrial proceedings that assumed Trump would present evidence about his state of mind. They'd been objecting to certain prosecution evidence as prejudicial or irrelevant based on the theory that Trump's testimony would provide counterbalancing evidence. They've been asking the court to exclude or limit evidence of Trump being told his fraud claims were false, arguing it was unfair to present one side of the story about what Trump was told without also presenting Trump's perspective on why he believed what he believed. Judge Chutkan was essentially saying, you can't have it both ways. You can't ask me to make evidentiary rulings based on the assumption Trump will testify and then keep your options open to not have him testify. Tell me now, is he testifying or not? According to multiple reporters present in the courtroom, Trump's lead attorney John Lauro turned visibly pale. He requested a recess to consult with his client, which Judge Chutkan granted. For 30 minutes, Trump and his legal team were huddled in a courthouse conference room having what witnesses describe as an incredibly heated discussion. Trump was reportedly furious, insisting he should testify because I can explain everything, while his lawyers were desperately trying to convince him that testifying would be legal suicide. Boris Epstein, Trump's political advisor, was apparently arguing that the political benefits of Trump testifying and proclaiming his innocence outweighed the legal risks. Meanwhile, the actual trial lawyers were trying to explain that politics don't matter if Trump confesses to crimes on the stand or commits perjury. When the hearing resumed, Lauro gave an answer that satisfied no one. He told Judge Chutkan, "Your Honor, we are not prepared to make a final decision on this strategic question at this time. We need to see how the trial develops, what evidence the prosecution presents, and what the state of the case is before we decide whether the defendant will testify." Judge Chutkan's response was devastating. "Counselor, I understand that's the typical approach, but you've made your client's state of mind the centerpiece of your defense. You can't build your entire defense strategy on claims about what your client believed and intended, and then refuse to commit to having him testify about those beliefs. Here's what I'm going to do. You have until December 1st to inform the court whether Mr. Trump will be testifying. If you indicate he will not testify, I will issue limiting instructions preventing defense counsel from arguing about Mr. Trump's beliefs, intentions, or state of mind in opening statements. You can present other evidence if you have it, but you cannot ask the jury to speculate about what the defendant was thinking without testimony from the defendant himself." The courtroom went silent. This was an extraordinary ruling that fundamentally changed the dynamics of the case. Judge Chutkan was essentially forcing Trump to choose: testify and face devastating cross-examination, or stay silent and lose your primary defense. There was no middle ground, no way to have it both ways, and no escape from the choice. Trump's lawyers exchanged panicked looks. Lauro tried one more time. "Your Honor, with respect, this creates significant constitutional concerns about the defendant's right to remain silent and his right to control his own defense strategy." Judge Chutkan was ready for this argument. "Counselor, your client has an absolute right to remain silent. I'm not forcing him to testify, but he doesn't have a right to remain silent and still have his lawyers argue to the jury about his state of mind without evidence. The Fifth Amendment protects against compelled testimony. It doesn't give defendants the right to make unsubstantiated claims about their beliefs while hiding from cross-examination. If Mr. Trump wants to invoke his right not to testify, that's his choice. But choices have consequences. And the consequence is that the defense cannot present a state of mind defense without state of mind testimony." Legal experts immediately recognized the brilliance of Judge Chutkan's strategy. She wasn't forcing Trump to testify. That would be unconstitutional. She was simply pointing out that if Trump wants to make certain arguments, he has to provide evidence for them. And the only person who can provide that evidence is Trump, by setting a deadline for Trump to decide. She was preventing his lawyers from continuing to make arguments about Trump's beliefs throughout pre-trial proceedings, and then pulling back at trial, if convenient. Now Trump had to commit, and either choice was devastating. This whole scenario has caused absolute chaos within Trump's legal and political operation. The deadline Judge Chutkan set was December 1st, which means Trump and his team have just over a week to make what might be the most consequential decision of the entire case. Those experienced criminal defense lawyers on Trump's team are unanimous. Trump absolutely cannot testify. They know that putting Trump on the stand would be catastrophic, and they've seen how Trump performs in depositions and under questioning. He rambles, contradicts himself, admits damaging facts while trying to sound impressive, and cannot resist the urge to argue and attack even when it hurts him legally. They understand that Jack Smith's prosecutors are some of the most skilled cross-examiners in the country, and they will systematically destroy Trump's credibility and likely get him to admit to elements of the crimes charged. But Trump himself, along with his political advisors, see it differently. Trump has spent his entire life believing he can talk his way out of anything, that his charisma and persuasiveness can convince anyone of anything, and that he's smarter than the lawyers and prosecutors who think they can trip him up. He watches the case being tried in the media, sees himself being portrayed as a criminal, and believes that if he could just get in front of the jury and tell his side of the story, they'd understand and acquit him. His political advisors are reinforcing this instinct. They're telling Trump that not testifying makes him look guilty, that his base wants to see him fight, and that the video of Trump taking the stand and proclaiming his innocence would be powerful campaign material, even if the legal outcome is bad. They're viewing this through a political lens rather than a legal one, focused on how it plays with voters rather than whether it leads to conviction. Meanwhile, the lawyers are literally begging Trump not to testify. According to sources who spoke to the Washington Post, Trump's trial lawyers have told him in the bluntest possible terms that if he testifies, he will be convicted and possibly face additional perjury charges for lying on the stand. They've walked him through what cross-piss examination would look like, showing him all the evidence prosecutors have that contradicts his claims. They've explained that prosecutors will ask him yes or no questions that he can't answer without either admitting guilt or obviously lying, but Trump doesn't want to hear it. He's apparently convinced that he can handle the prosecutors, that he'll be able to explain everything to the jury's satisfaction, and that his lawyers are being overly cautious. He's made comments to aides suggesting he thinks his lawyers are weak for advising him not to testify. And he's reportedly been watching old videos of himself giving speeches and interviews, convincing himself that he can perform just as well on the witness stand when a defendant is this disconnected from legal reality and this convinced of his own abilities despite all evidence to the contrary. Disaster is looming. Now, let's talk about what Trump's cross-examination would actually look like if he does decide to testify, because understanding this helps explain why his lawyers are so adamant he cannot take the stand. Jack Smith's prosecutors have spent over a year investigating this case. They have testimony from dozens of witnesses, thousands of documents, recordings of Trump's phone calls, and Trump's own public statements and tweets. They know every inconsistency in Trump's story, every lie he told, every person who warned him his fraud claims were false, and every piece of evidence showing he knew he lost the election. If Trump takes the stand, prosecutors will systematically walk him through all of this evidence, forcing him to either admit damaging facts or deny things that are provably true. For example, prosecutors will ask Trump about his call with Georgia Secretary of State Brad Raffensperger. They'll play the recording where Trump says, "I just want to find 11,780 votes." And then they'll ask Trump, "Mr. Trump, when you asked Secretary Raffensperger to find exactly the number of votes you needed to win Georgia, were you asking him to fabricate votes?" If Trump says yes, he's admitted to a crime. If Trump says no, prosecutors will ask then, "What did you mean by find votes?" Trump will try to deflect and explain, but prosecutors will keep asking yes or no questions. Did you believe there were 11,780 legitimate votes that had been wrongly excluded from the count? Yes or no. If Trump says yes, prosecutors will ask, "What was your evidence for that belief?" and force Trump to either admit he had no evidence or make claims that are provably false. They'll confront Trump with testimony from Attorney General Bill Barr, who told Trump directly that there was no evidence of fraud sufficient to overturn the election. They'll ask, "Mr. Trump, Attorney General Barr was your appointee, correct? Someone you chose because you trusted his judgment." Trump will have to say yes. And he told you in early December 2020 that the Justice Department had investigated fraud claims and found no evidence of widespread fraud, correct? If Trump denies this, prosecutors will play video of Barr's testimony saying exactly that. So when your own attorney general, someone you appointed, told you there was no fraud, why didn't you believe him? Trump will try to explain that he was hearing different things from other people, that he had other sources of information. Prosecutors will then walk through each of those other sources systematically. You mentioned Rudy Giuliani. Mr. Giuliani was a lawyer representing you personally, not an investigator with subpoena power, correct? Mr. Giuliani's fraud claims were thrown out by over 60 courts, correct? Not a single court, including courts with Trump-appointed judges, found evidence supporting Mr. Giuliani's claims, correct? Each question will box Trump in further, forcing him to either admit his fraud claims were baseless or defend positions that have been thoroughly debunked. Prosecutors will ask about the fake electors scheme. Mr. Trump, you were aware that your campaign was organizing slates of fake electors in states you had lost, correct? If Trump denies knowing about it, prosecutors will present documentary evidence and witness testimony showing he was directly involved. If Trump admits knowing about it, prosecutors will ask, "You understood these were not the actual electors certified by the states, correct? And you understood that submitting false electoral certificates to Congress was an attempt to create fraudulent documentation, correct?" Every answer Trump gives will either contradict other evidence or admit to criminal conduct. They'll ask about January 6. Mr. Trump, you were told that Vice President Pence did not have the legal authority to reject electoral votes, correct? You were told this by your own White House counsel, correct? You were told this by Vice President Pence himself, correct? Despite being told by multiple lawyers that your theory was wrong, you publicly pressured Vice President Pence to reject electoral votes anyway, correct? When your supporters marched to the Capitol chanting, "Hang Mike Pence," you didn't immediately call them off, correct? For over 3 hours, while the Capitol was under attack, you didn't call in the National Guard or order your supporters to leave, correct? Each question builds on the last, creating a narrative of Trump knowingly pursuing an illegal scheme to overturn the election. And here's the thing about cross-examination. Trump won't be able to give his usual rambling, deflecting answers. When prosecutors ask a yes or no question, the judge will instruct Trump to answer yes or no. If Trump tries to dodge or give a speech, prosecutors will say, "Your Honor, please instruct the witness to answer the question," and Judge Chutkan will tell Trump he must answer directly. Trump has never been in a situation where he can't talk his way around questions, where he's forced to give direct answers, and where every dodge and deflection is stopped by a judge enforcing courtroom rules. It will be excruciating for him and devastating for his defense. Legal experts who've analyzed the evidence in this case are unanimous that Trump cannot survive cross-examination. Barbara McQuaid, former U.S. attorney and current law professor, appeared on MSNBC and stated, "If Trump testifies, he'll be convicted. It's that simple." The prosecutors have so much evidence contradicting his claims that cross-examination will be a systematic destruction of his credibility. He'll either have to admit he knew the fraud claims were false, which proves criminal intent, or he'll have to deny things are provably true, which will make him look like a liar and likely lead to perjury charges. There's no version of Trump's testimony that doesn't end in conviction. Andrew Weissman, former Mueller investigation prosecutor, wrote in an analysis piece, "Judge Chutkan has put Trump in a legal vice. His defense theory requires him to testify, but testifying will destroy his defense. This is a brilliant strategic judging, forcing the defendant to choose between two paths that both lead to conviction. If Trump doesn't testify, the jury won't hear any explanation for why he disbelieved everyone telling him the truth. If he does testify, the jury will watch him get confronted with overwhelming evidence of his guilt. Either way, conviction becomes nearly inevitable." Even some lawyers sympathetic to Trump have privately acknowledged the disaster that would result from his testimony. According to reporting from The Atlantic, one lawyer who previously represented Trump in a different matter said on background, "Donald Trump is the worst witness imaginable. He can't answer a simple question simply. He can't resist the urge to brag and exaggerate. He can't admit he was wrong about anything ever. And he's completely incapable of following his lawyer's instructions to keep answers short and stick to the facts. Any competent prosecutor will destroy him on the stand. The only question is whether it takes 3 hours or 3 days." So let's break down what Trump's decision will mean for the case going forward, because both options lead to very different but equally terrible outcomes. First, if Trump decides not to testify, Judge Chutkan will issue limiting instructions preventing Trump's lawyers from arguing about his state of mind, beliefs, or intentions. In opening statements, Trump's lawyers won't be able to tell the jury, "President Trump genuinely believed the election was stolen." In closing arguments, they won't be able to say the prosecution hasn't proven President Trump knew his fraud claims were false. The judge will specifically instruct the jury that they cannot speculate about Trump's beliefs or intentions based on what his lawyers say. They can only consider actual evidence presented at trial. Without Trump's testimony, there will be no evidence of his state of mind from the defense. The prosecution will present overwhelming evidence that Trump was told repeatedly his fraud claims were false, and there will be no countervailing testimony explaining why Trump believed otherwise. The jury will hear from Bill Barr saying he told Trump there was no fraud, from White House counsel Pat Cipollone saying he told Trump the legal theories were wrong, from campaign officials saying they found no evidence of fraud, and the defense won't be able to respond with Trump's explanation of why he disbelieved all these people. The case will essentially become about actions and knowledge, not beliefs. Did Trump do the things charged? Yes, those actions are largely undisputed. Did Trump know he lost the election? The evidence overwhelmingly shows yes. Without Trump's testimony to create doubt about his knowledge and beliefs, The jury will almost certainly convict based on the actions and knowledge alone. And honestly, that's a terrible outcome for Trump. The only real defense he has is the good faith belief argument. Without it, he's left trying to argue that the prosecution hasn't proven every element beyond a testify would reveal he knew exactly what he was doing and did it anyway. The reason Trump can't answer Judge Chutkan's questions is because honest answers prove his guilt. For over 250 years in American democracy, the principle has been that criminal trials determine guilt based on evidence and testimony, not political power or public relations. Defendants who are actually innocent typically testify to explain their actions and establish their innocence. Defendants who are guilty typically don't testify because they know cross-examination will expose their lies. By forcing Trump to choose whether to testify, Judge Chutkan is forcing him to reveal whether he has an innocent explanation for his conduct or not. The fact that Trump's lawyers are desperately trying to avoid having him testify tells you everything you need to know about whether he can actually defend his actions honestly. So the implications of this ruling reach far beyond just trial strategy. It's about whether Trump can hide behind lawyers, arguments, and political rhetoric, or whether he has to face direct questioning about his conduct. Each time Trump tries to avoid accountability by hiding from testimony and gets forced by a judge to either testify or abandon his defense, it reveals that he has no good answers. It starts establishing a pattern that powerful defendants can't manipulate the system by making claims they won't defend under oath. Think about it. If Trump can argue he had good faith beliefs without having to testify about those beliefs and subject them to scrutiny, what's to stop every defendant from doing the same? If wealthy defendants can hide behind lawyers while making unsubstantiated claims about their state of mind, what does that say about the fairness of the justice system? If defendants can build entire defense strategies on claims they won't testify to support, how can juries ever determine the truth? Judge Chutkan's ruling addresses all of this. She's saying the system doesn't work that way. If you make claims, you have to support them with evidence. And if the only evidence is your own testimony, you have to be willing to give that testimony and face cross-examination. It's a fundamental principle of fairness and truth-seeking that applies to everyone equally, even former presidents. So here's the deal. Donald Trump has until December 1st to decide whether he's testify in his federal election interference trial, and both options are catastrophic. If he testifies, prosecutors will systematically destroy him on cross-examination. He'll likely admit to elements of the crimes charged, and he may face additional perjury charges for lying on the stand. If he doesn't testify, he loses his only viable defense theory and faces conviction based on overwhelming evidence of actions and knowledge without any explanation of innocent intent. This isn't just a difficult strategic choice. It's a forced confession that Trump cannot defend his conduct honestly. Judge Chutkan has created a situation where Trump's only options are explicit admission of guilt through testimony or implicit admission through silence. Either way, the truth about Trump's conduct after the 2020 election is going to be established through evidence he cannot refute or explain away. It's about so much more than just whether Trump takes the stand. It's about whether someone can attempt to overthrow American democracy and then avoid accountability by hiding behind legal technicalities and refusing to answer for their actions. Judge Chutkan has made clear that in her courtroom, defendants who want to claim innocence based on their state of mind and have to be willing to testify about that state of mind. So keep an eye on December 1st because Trump's decision will reveal everything about his case. If he announces he won't testify, you'll know his lawyers have convinced him he cannot survive cross-examination. If he announces he will testify, you'll know his ego has overruled his. Lawyers' advice and disaster is imminent, and the next few weeks are going to be absolutely crucial. Stakes have never been higher, the trap never tighter, and Trump's options never bleaker. This ride is far from over, but Trump just realized he's lost control entirely. And there's no way out that doesn't end in devastating consequences.